You say you haven't been the same since you had your little crash, but you might feel better if they gave you some cash. The more I think about it, old Billy was right. Let's kill all the lawyers, kill them tonight. You don't want to work, you want to live like a king.
It's me, it's Ernest T.
Hey, Ernest T is here.
Hey, man.
How you doing today?
Good. It's time for another episode of Two Marks and One Mic.
Or 2 marks, 1 mic. However you want to say it. Doesn't matter.
You know, as trial lawyers, every month we get an issue of the Tennessee Jury Verdict Reporter, and I go through it to pick out, to really make me feel good about my cases, because there's some cases in these reporter that are just cases from hell.
Well, and you know, there's one in here particularly this time that we both kind of taken a look at that gives us an opportunity to talk about what comparative fault means in Tennessee.
And what slip and fall premises liability means in Tennessee. Right. How many times do you take a phone call where someone calls up and falls in a business and thinks they're automatically entitled to their medical bills being paid?
That's right. Yeah, we get those frequently. So just because you fall on somebody else's property does not mean
automatically
that the property owner
slam dunk
that
no,
they're responsible. It does not mean
we
that.
have to show that the property owner knew or should have known about a defect in the premises. For example, an easy example would be raining outside, leaky roof, puddle in the floor that they knew about, they never did fix. You walk in there, slip in that puddle, and hurt yourself. That's an example, a slam dunk case where the property owner knew or should have known about that puddle in the floor. Now,
that's correct.
But it's not even slam dunk. That's not even slam dunk.
That's not even slam dunk, because premises cases can be difficult. So that gives us a basis. The facts that you just talked about is that shows that one of the elements that you have to establish in a premises case is that the owner of the property or the person that's renting the property, whoever's responsible for that property, had knowledge of that defective condition. So that's just one thing, knowledge. Whether the knowledge is actual knowledge or existed for a sufficient period of time that they had constructive knowledge that they should have known. So that's that first element you're talking about.
And this case today we're going to be talking about is a case that happened at a bar, which is always a bad sign. Cowboy Saloon in Columbia, Tennessee. Cowboy Saloon in Columbia, Tennessee. The plaintiff parked with his girlfriend at an adjacent parking lot at a place called Tobacco for Less. So you could probably envision where this saloon is next to a store called Tobacco for Less. Yes. He parked there, he walked in the bar. Now, whenever you have a bar and alcohol is involved, either a plaintiff or a defendant, how many beers do they typically have?
Well, they always have 2 beers.
2 beers, and always 2 beers.
Yeah.
Now, why not just 1 beer?
Well, because you can't just drink one.
Very good.
It's like a lazy potato chip.
Okay. So why not 3 beers?
Well, because then you get over the limit.
Right. So every 34 years, plaintiff or defendant, my client or the defendant driving a car, it's always 2 beers. It's always 2 beers.
Well, in this particular case,
it was 2 warm beers.
Exactly.
It was 2 warm beers that he didn't finish.
And remember, in this particular case, is that when this guy walked from this parking lot of the tobacco store next door and walked into this bar had a sign out by the road where they actually had an extension cord to light the sign.
Classy place.
So what in this particular case, what this defective condition was this extension cord that went out to the sign.
Yeah.
So this guy leaves the tobacco store parking lot, walks
with his girlfriend,
steps across this extension cord,
walks across
and goes into the bar.
Okay.
The bar. So
he orders a beer. It was warm, so he didn't finish it because he knows that he can't be drunk and have a claim. So he orders 1 beer. He says it's warm, so he didn't finish it. He orders a second beer. There you go, 2 beers, 2 beers. And he didn't finish that beer either because it was warm.
Exactly.
So I'm kind of going, okay, all right, that sounds okay. You had 2 warm beers. You didn't finish it. So what happens next?
Well, so at least the facts in this case, he decides to switch to moonshine.
Yes, moonshine. He had moonshine shots.
He had moonshine shots.
With his friends.
Now, the facts that's reported, it's unclear whether the moonshine shots were purchased at the bar or whether somebody had brought it in a jar.
Exactly.
So
it's a Cowboy Saloon. Of course, the Cowboys brought it in.
But it's a good point about the second thing was about the extension cord.
Yeah.
Now we know that this bar had notice of the extension cord, so that's established because they're the ones that put it there, and the facts suggest that that extension cord had been there for a long,
Check.
long time.
The owner of the premises have got to know about the defect, either did it themselves or had known about it long enough where they should have fixed it. So we have that check mark right there.
Exactly.
So that's a plus for the plaintiff. Negative for the plaintiff for shots of moonshine. Okay.
Right.
Okay. Plus for the plaintiff, he walked in without hitting the cord. The cord out there. Negative for the plaintiff, when he walked out, what happened?
Well, we know he had part of 2 warm beers and moonshine.
And moonshine. Okay, so that's not good.
That's
not good. So he walks out of the bar, going back to his car, parked in Tobacco for Less with his girlfriend. He catches his foot on the wire, the wire that was there, falls and hits his knee.
Correct.
Hits his knee. Now his girlfriend said that when he fell and hit his knee, his shoes came off. His shoe went up in the air.
And there's an expletive, I think, that was associated with how that happened.
Okay, so
we don't know what that is.
Well, still, so the girlfriend sees a shoe flying up in the air, but if you fall, if you trip and hit your knee, just the physical ability to have your shoe go up in the air. I'm not sure what happened with that, But he hit his knee, and he has a road rash because of that right there. Okay,
So what we know about this case, if we look just at the facts and don't comment at this point on how truthful or how believable these people may have been, what we know is this condition existed.
Right.
We know that this guy went into the bar. We know that when he came out, he actually fell over this existing condition.
And he had some moonshine.
So what does a jury do once they have these facts? If you look at just those bare facts, it looks like, gosh, the condition existed. The bar knew about it. He came out. He tripped over this wire. So the condition that existed that was created by the bar actually resulted in his injuries.
There's something in Tennessee called comparative fault. Comparative fault. Back in the day, back in 1992, there was no such thing as comparative fault. There was a case that came out in 1992 that actually established comparative fault, where the jury assesses the fault of the property owner for having that wire out there with the fault of the plaintiff for having moonshine shots and walking out to his car.
And I imagine in this particular case, even though the facts that we have don't give us a lot of detail, I'm sure part of the arguments were that the person that ended up falling also had knowledge of the wire because he stepped across it.
Right.
That does not necessarily mean he had knowledge. His knowledge may not have been superior to the owner's knowledge, but I imagine that was part of the argument. Yeah. The second thing, as you talked about, another thing that may have contributed to his comparative fault is that he'd been in there drinking warm beers and hitting moonshine.
Hitting moonshine, right. The other thing that a lawyer looks at in evaluating cases, not only liability, and liability here is, kind of fuzzy, it's not a slam dunk. We have arguments on both sides, but for us to get involved as a lawyer, spend our time, because we don't get paid unless you get paid, so we want to make sure that we have damages also. Now, this guy had some damages. He had $78,000 in medical bills because he had to have a knee replacement surgery on the very knee he hit.
That's correct.
Now, bear in mind, he was on disability for this same knee.
Right.
Okay?
So that raises some other issues that you can see in a case, and that is whether the damages that you sustained were really caused by the event or aggravated by the event. So in Tennessee, we have to rely on medical proof to establish that it's either caused by this particular fall or the pre-existing condition he may have had was aggravated by this fall.
He actually had 2 previous surgeries on this same knee before this fall. So damages are kind of like, that's going to be a problem there.
It becomes
2 previous surgeries on the same knee. You're on disability for this knee. You're drinking moonshine. You're heading out. You have fall. Your shoe flies up, and this poor plaintiff lawyer, I guess, had no settlement value at all. Nothing was offered by the saloon to settle this case.
We assume it wasn't.
Because,
he tried it.
He had to try this case. Right. He had to try this case, and the jury was out for 1 hour. Okay, you have a 3-day trial, and the jury verdict is within 1 hour. Is that good or bad for the plaintiff? That's bad for the plaintiff. I tell you that right now.
Generally, the shorter the time period, the worse it is.
Yes. because the shorter the time period, the jury's not having much discussion on. Let's talk about liability here. Let's talk about damages here. No,
Because the process the jury goes through is the analysis of these elements that we're talking about. Was there notice of the condition?
Right.
If there was notice of the condition, okay, yeah, they knew about it. The owners knew about it, and then they're going to start comparing
Right.
fault.
Yeah.
And if they compare fault and they know that the property owner has a less percentage of fault than the actual injured party, they don't even need to get to the third part of the analysis.
Right.
That is the damages.
Well, that's what will happen
So
here.
that's what
The jury, after an hour, found this moonshine drinking cowboy 90% at fault.
That's
for
correct.
his injuries, and 90%. I mean, if you're 51% at fault for your injuries, plaintiff loses.
Correct.
Okay, defendant wins. They found the plaintiff was 90% at fault. They found 10% fault, I guess, on the saloon because the wire was there. Right?
Exactly right. So that's the way this comparative fault works in Tennessee. We picked this case because it illustrates a few things. It illustrates how you compare a plaintiff or the injured party's fault with the property owner's fault. And this also, we do this in car wrecks too, when you have a question of how an accident may have happened.
Right.
But you compare these two to determine the percentage of fault that each party may have.
And a car wreck case would be like you're at a stop sign, you look both ways, you pull out, other side hits you, and you're claiming, I did pull out, but the other car was speeding. And so you have the speeding with you pulling out, and the jury's able to assess the fault between the two parties. But this is, in my opinion, a case from hell for the plaintiff on liability and damages, and I feel sorry for the plaintiff lawyer. He didn't get paid. His client didn't get paid. But I guess the saloon is still there, serving more beer.
And I guess the advice that we need to put out there based on this case is the saloon should sell cold beer.
Yeah, exactly. This case would have never happened if he had cold beer.
It may not have ever happened with
Well, there would be need for the shots.
Yeah,
That cold beer. So
he would have had his 2 cold beers, wouldn't have been of limit, would have gone and gotten his car.
That's
with
the
his girlfriend and
takeaway.
gone home.
Exactly. That's the takeaway from this case. Be sure and serve cold beer. This has been 2 Marks, and
1 mic, or 2 marks, 1 mic.
see you next time.